There are two types of personal bankruptcy in the United States, Chapter 7 and Chapter 13. In Chapter 7 bankruptcy, all or part of your debts are discharged after your non-exempt assets are sold to repay some of the debt. To qualify for Chapter 7, you must have very little disposable income and you must pass the means test. The income for the means test varies by state. The means test has two steps. The first step looks at whether your income is less than the median in the state in which you live. If your income is less than the median for the previous 6 months, and there is no reason to think that your income will increase soon, the first step is passed. If you pass, then you can move to filing for Chapter 7 bankruptcy. If you fail Step 1, then you move to Step 2. Step 2 requires you to document how much of your money was spent on things like rent or mortgage, food, medical bills, and other essentials. These items are considered allowable expenses. The court will look at the information you supply very carefully to see if you miscategorized any amounts. It will then compare your expenses to government data and make a determination as to whether your spending is excessive. If you pass this second step, then you can proceed to filing for Chapter 7. A discharge for Chapter 7 bankruptcy usually takes from 3 to 5 months. In your filing, in some states, you can choose to follow either federal law or state law. Exempt assets vary by state. Depending on your situation, this choice can benefit you. For example, Florida has one of the most generous homestead exemptions in the entire country. If your home is worth more than you owe on it, the Florida homestead exemption can allow you to keep the home if you file for Chapter 7 bankruptcy. In Florida, you may also be able to keep an unlimited amount of value in your home if your lot is less than half an acre in a municipality or 160 acres outside of a municipality. This is much more generous than the $22,975 of home equity you are allowed to keep under the federal homestead exemption. Back to general bankruptcy rules under federal law. Exempt property includes your house, the car you drive to work, professional tools, Social Security, pensions, veterans benefits, welfare, and retirement savings. In general, be prepared for relatively low federal exemption allowances. Non-exempt property includes things like cash, bank accounts, stock investments, a second car, a second home, etc. The non-exempt property will be sold by a bankruptcy trustee appointed by the court. The cash from the sales will pay the trustee the administrative fees and your creditors to the extent possible. But bankruptcy does not remove the following types of debt: federal student loans, alimony and child support, debts incurred after filing bankruptcy, some debts in the 6 months before filing bankruptcy, taxes, fraudulent loans, debts from personal injury while driving intoxicated, and any debts where you've had a co-signer. Bankruptcy is very complex, so it is wise to get legal help of some kind on either a free or a fee basis.